For Moriarty.
Thank you, sir. I am grateful for the opportunity to speak on the Summary Offences High-Risk Missing Persons Amendment Bill. I've appreciated the opportunity to hear from the Minister. I'm also much persuaded by some of the points made by the Honourable Nicola Centofanti in the other House. And for the benefit of members in this House, I want to share some of her comments. I'll paraphrase. Yes, I'll paraphrase.
That's okay.
And speaking as, again, lead speaker on behalf of the opposition, appreciate the opportunity to take my full measure. So this bill was introduced by the Attorney-General earlier this month, seeks to amend the Summary Offences Act 1953 so that a proportionate set of tools can be made available to police in order to respond to missing persons cases designated to be at high risk. We, of course, support the rapid and lawful search activities being enabled by these reforms, especially where there is a vulnerable person who is missing and where, even in the absence of suspected criminality, urgent action is required. So there's, as you'd be aware from your time as a police minister, there is a legislative model in Queensland which was recently reviewed, and that review found that while powers are rarely invoked, there is a benefit in that they can be critical to enable an investigation to progress in order that a missing person may be located as swiftly as possible. Clause 3 of this bill makes an amendment to section 83C so that a senior police officer may provide the relevant authorisation for entry to a specified premise or a vehicle or a vessel or place for up to 48 hours for the purpose to enable the investigation and whatever necessary action is necessary to locate a high-risk missing person. Now, in relation to who is a high-risk missing person, it is a missing child under 14 or any individual who police reasonably believe may suffer serious harm if not found urgently. So there's also Clause 4, which inserts a new 83D into the Act. That allows a senior police officer to seek a warrant from a judge in similar circumstances. A warrant under this provision can remain in force not for just the 48 hours that the senior police officer's own authority can provide for, but indeed up to 90 days. So, in the case where there are more complex or extended searches that are necessary, that ongoing lawful authority remains. SAPOL has advised that, having discussed the matter with their colleagues in Queensland, they consider these powers to be valuable but indeed tightly bounded, so rarely used but essential when time is critical. So, clearly it's important these measures have safeguards. Clearly it's important that the public has confidence, and indeed police have confidence in their own powers to do this work rapidly as necessary to locate vulnerable people. The Liberal Party is satisfied in the safeguards, satisfied in the intent, and supports the bill.
Any other speakers? There have been other speakers. The Minister, if the Minister speaks, he'll close the debate.
Thank you, sir. I knew that I was right in preemptively thanking the member for Moriarty. It was a fine contribution, and in doing so, I commend the bill to the House.
Question before the Chair is that the bill be read a second time. All those in favour say aye, those against say no. I call it for the ayes. Madam Clerk.
An Act to amend the Summary Offences Act 1953.
There's no amendments. No need for a committee. No. You're good. Okay. Question. Minister, would you like to move that bill be read a third time?
Yeah, thank you, sir. I move the bill now be read a third time.
The question before the Chair is that the bill be read a third time. All those in favour say aye, those against say no. I call it for the ayes. Madam Clerk.
An Act to amend the Summary Offences Act 1953.